The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 515-207-2006. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Iowa. We're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, I'm Gene Nassif, an attorney at O'Flaherty Law. My practice areas include business transactional matters as well as some family law and landlord-tenant issues. Now, today we're going to talk about how somebody forms a trust in Iowa. Trusts are common tools used in estate plannings or other situations where you want a third party to take control of an owner's property and allow it to be distributed to another third party. Well, the creation of trusts involves several unfamiliar legal terms. The basic idea is to allow somebody else to hold onto your property for the benefit of a third person. In other words, you entrust with somebody to take care of a certain piece of property for somebody you might care about. The following video will cover what is a trust in Iowa, what are the requirements for trusts, what are the requirements for a valid trust, how a trust is created, any limitations to a trust, and how Iowa treats trusts made in other states. We'll first address what is a trust. A trust is created when one person gives to a second person or additional people the ability to manage some of their assets for the benefit of a beneficiary or beneficiaries. The person who creates a trust is called the settlor or trustor. The person who holds or manages the property for its owner is the trustee. A person who benefits from the trust is called a beneficiary. The same person may have multiple titles. For instance, a settlor can be a trustee and a beneficiary as well, so long as at least one or more trustee or beneficiary is added. There are many kinds of trusts. Trusts may control how a settlor's property is distributed during a person's life, or a trust may take effect upon a person's death. A trust may be formed for the benefit of the settlor, for instance, if they don't trust themselves with their own money, the settlor's family members, charitable organizations, or other beneficiaries. Trusts are often used as estate planning tools as they allow assets to avoid probate, allowing a settlor to have greater control over how their assets are distributed once they pass away. A trust can be formed in multiple ways. However, the enforcement by a court requires the following steps to be created. Are there requirements that trusts can be reduced into writing to be enforceable? An otherwise valid trust is enforceable in court if it's put into writing and signed by the trustee. It also is enforceable if it is reduced to writing, handing over the trust property and signed by the settlor. A settlor must declare the property is held in the trust. The writing must be signed by the owner before and at the time of the declaration. A trust is also valid if it is signed after the time of the declaration, but before the settlor has transferred the property. A trustee can also sign the document to make it enforceable. It should be signed at the same time or before the transfer, or it may be signed by the trustee after the transfer, but before the trustee has transferred the property to a third person. Oral trusts that have not been reduced into writing are not enforceable in Iowa courts. Now, what are the requirements for a valid trust? All of the following must be satisfied to create a valid trust. The settlor must be mentally capable and intending to create the trust. The same person is not the sole trustee and sole beneficiary. The trust has a definite beneficiary and/or beneficiary who is soon to become known. And finally, the trustee has duties to perform. A trustee, under limited circumstances, can control who is given the assets that are held in the trust. If a reasonable time passes and the trustee has not done this, the property will go to the person who would receive the property if the power were given to them, such as under a will or intestacy laws. What are the ways to create a trust? A trust is enforceable and valid if it meets the above requirements. The trust is actually created by one of the following methods: transfer of the property to another person as trustee during the settler's lifetime, or by will taking effect upon the settler's death, declaration by the owner of the property that the owner of the property holds the property as trustee, exercise of the power of appointment, such as if a person was appointed as a personal representative as an estate in favor of another person as trustee, and finally, a promise enforceable by the trustee to transfer the property to itself. Are there any limitations to the purpose of a trust? A trust can only be created for a private, including estate planning, or charitable purposes that is not for any legal purpose or against public policy. A trust can be private and must be administered for the benefit of its beneficiaries. Finally, what if the trust was created in another jurisdiction? How is it enforceable in Iowa? Iowa recognizes trusts which are validly created in other jurisdictions in which the trust instrument was executed, or the law of the jurisdiction where the settler was domiciled at the time. So, if a trust was created in a state where the trust creation laws are different from Iowa, a court will look at the laws of that state to determine whether or not the trust is valid. In other words, it likely is enforceable. As always, if you have any additional questions, feel free to reach out to our firm. Thank you very much and have a nice day.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed this video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 515-207-2006. We have many locations for your convenience. We serve all of Iowa. Thank you again for watching.